Good evening to all of you and my
Just hold on.
Yeah.
Good evening, and we have amongst us Mr. L Rajah, Senior Advocate from Madras High Court. And those who have been connected with Beyond Law CLC would have seen that Mr. Rajah, akin to his name, has taken sessions which are larger than what we can actually think of. And this is, in fact, a part two of what we can say of the important judgments on the arbitration. Or in this particular session, we will have part examining what has been laid down recently and what are the recent trends in this regard. And we are glad that Mr. L Rajah, who is a known name in not only as an advocate, but also for his knowledge sharing under the banner of Nanki Palki Wala. And we will also share the link in respect of the sessions which they have started to assimilate yourself in respect of the arbitration. We know that it's a weekend, and we'll request Sir to take over from where we left last time. Over to you, sir.
Good evening to all of you. I think you are all a group of people who are thirsty for knowledge because you have pulled yourself away from whatever distractions that a Sunday evening can offer to listen to some presentation on case laws under the Arbitration Act. This speaks volumes of your interest in this on this subject, which is a fast-growing subject and is very important for any practitioner of civil law. Now, during this course of about 45 minutes, I will try to, I know that the attention span of generally human beings is very limited, and to subject you to long 1.5 hours, 2 hours presentations is actually counterproductive because nothing much will then register. So I hope to be pointed and clear on certain aspects which are important for you to observe as a person who is interested in arbitration law. Because of the enormous backlogs that we have in court today, one of the most sought after recourses is alternate dispute resolution. So, and within alternate dispute resolution, which encompasses things like mediation, arbitration, lok adalats, and those offered by government agencies, those offered by private companies, even consumer courts. Amongst all this, obviously, arbitration is attracting a lot of attention because arbitration is key to resolving the problem of ballooning arrears in this country. So a well-regulated and a well-executed arbitration regime has become extremely important for the well-being of our legal system itself today. We must also understand that as against the practice in many countries, Indian Parliament, except in the last, let's say, a decade, has not tracked the changes to arbitration law and come up with, amendments that will resolve the problems. For example, let's take the period between 2000 to 2016. The Singapore arbitration law was amended about 6 times because every time the court pointed out that there were flaws in the act, or when there were 2 or 3 judgments of courts which did not see eye to eye with each other, and there were conflicts in the law in the manner in which courts interpreted the provisions, immediately the Parliament would step in and would amend the law. So between 2000 to 2016, which is a sort of a block period that I have looked at, Singapore Arbitration Act went through 6 amendments. Unfortunately, the Indian law during that entire period went through only 1 amendment. I was part of the consultation committee, which was put in place by Justice A.P. Shah when he was chairman of the Law Commission of India. 10 of us participated in the deliberations. These deliberations went on for a long period of time. And in the deliberations, representatives of the government also participated, so that we did not want to give an act. We did not want to give our recommendations which would get stuck with the government. Therefore, we took the government also into confidence, and government representatives, law ministry, and various representatives of PSUs also attended the conference. And with that, substantial progress was made in bringing out amendments which have, I hope, changed or contributed to the good of the arbitration landscape in this country. Now, given that background, no law is perfect, and therefore laws will face their challenge from time to time. Courts will try to resolve it at some level. If there is to be consistency between various judgments of courts, well and good. But then once again, there are problems, and therefore the best way to resolve these is for the parliament to go in for amendment. In fact, I should say it is a very commendable thing that the Indian Parliament has once again seized of some attempts to amend the Arbitration Conciliation Act to make it more purposeful and to make it more effective. So these are the two things that are very, very important to make a law function well. And therefore, the steps that are being taken by the government to bring in some amendments, probably Vikas can host a separate program on what these amendments are and how it will change the arbitral regime. But these are very interesting amendments that are going to be brought in. We don't know whether it will be passed by the parliament or when it will be passed by the parliament. But the thing is that as practitioners of law, we need to educate ourselves that there are going to be these amendments and that they will impact the arbitral regime. But keeping this in mind, today let me deal with some case laws which I think are going to be important in terms of their huge impact on the arbitral regime and how courts, because the general idea under the Arbitration Conciliation Act is that it encourages or rather prescribes least intervention by courts. But then given the regime and the legal system that we operate in, this has still been at the stage of only being a pipe dream. It doesn't really happen. Sometimes it is good, sometimes it is bad, and it is very difficult to say whether it is assertively say whether this is good or bad. But the fact is that courts do intervene. And courts do intervene because we don't have as yet a well-developed institutional arbitration setup in the country. And still close to 80% of all arbitrations that happen in the country are actually ad hoc arbitrations. This contributes to a lot of confusion in the manner in which the arbitration proceeds. And therefore, this is a problem. This is a problem that the country has to take into account. But be that as it may, as the law stands, there are certain judgments which are important. And as practitioners of arbitration law, it is essential that you must make note of them. Now, the first judgment, which is a very recent one, is the judgment of a 5-judge bench of the Supreme Court in Central Organization for Railway Electrification versus Messrs. ECI SPIC. Now, this is significant for two reasons, because it impacts the manner in which PSUs appoint arbitrators. It's also important for deciding the manner in which NBFCs appoint arbitrators. What has happened till now was that the NBFCs and PSUs would have arbitration clauses, and the arbitration clause would stipulate that if there were to be difference between parties, then one of the parties or the managing director of one of the parties would appoint an arbitrator, and the arbitral process will then proceed on the basis of such appointment. Earlier, these were challenged before the Supreme Court as not being very equitable and was not in line with the provisions of the Arbitration Conciliation Act. However, the Supreme Court in Tata Switchgear Limited versus Tata Finance Limited, which is reported in 2008 SEC page 151, held that there is nothing wrong with this process at all. Now, this was the judgment that was rendered by the Supreme Court in 2000, and this has been followed consistently. Now, what happened in the meantime was that these 2015 amendments came to be passed. The 2015 amendments had two significant provisions. One was Section 12, which was the basis of, or the parent section that gave legitimacy to Schedules 5 and 7 of the Arbitration Conciliation Act. These two schedules set out a causes which were indicative of bias on the part of the arbitrator, and therefore one class of cases would require a declaration of interest, and B, there were another class of cases where such interest was fatal to the arbitration itself, and therefore if that interest was found to exist, then the appointment of the arbitrator itself would be bad. These are found in, as I said, Schedule 5 and Schedule 7. Of course, subclause 5 of Section 12 said that even if there were these disqualifications, but after the disputes have arisen, it is open to the parties to waive these disqualifications. So there really is no category of disqualification which applies totally as far as Indian arbitration law is concerned. Both parties, by invoking clause 12(5), let's assume there is an NBFC which appoints its own managing director. The law as it stands today is that after the disputes have arisen, both parties could get together and say that it is all right, even though I have appointed my managing director, there is nothing wrong in the appointment, and both of us agree to proceed on this basis. But as we know, many people are not going to do that. So 12(5) is actually a toothless tiger. Nothing that you can do with 12(5), because by the time a dispute arises, both parties are not in a position to concede anything which the other party is asking them to do, and therefore this provision is of little help. But as I said, technically, there is this provision. NBFCs pointed out that this causes a lot of problems to the manner in which they do business. According to them, there are nearly, it is said that there are close to 2 lakh arbitrations that happen within the state of Tamil Nadu, right? Every NBFC has an arbitration clause, and if there is a default, then the proper course open to the NBFC is to appoint an arbitrator and to proceed and get an arbitration award. These are all very, very small claims. They may not exceed more than 20 lakhs. And of course, NBFCs also have the advantage of approaching SARFAESI, provided the limit is more than 20 lakhs. But many of them have preferred to go through this arbitration route. They appoint their own arbitrator, notices are sent to the parties, but courts started frowning on certain aspects of the matter in which these were conducted. These principally related to two factors. One, it said, we find that the same NBFC appoints close to a same arbitrator for more than 200 to 300 disputes. So the courts found this very disturbing. The courts also said that many times the seat of an arbitration in an NBFC dispute is in a faraway location. For example, if the borrower is in West Bengal and he has taken a loan in West Bengal, and the NBFC has a branch office in West Bengal, but if it stipulates that the seat of the arbitration will be at Chennai, then it involves that this poor borrower, whose borrowing may not be very much, will still have to travel all the way to Chennai to conduct the arbitration. This courts have always frowned on as being a very inequitable state of affairs. The second thing that concerned the courts was that there was no facility for an online dispute model by which the person could participate from wherever he was, because the growth of technology today and possibly every human being having access to a cell phone, and or a computer, it is possible for him to send his claim online. It is possible for the other side to send their response online. It is possible for the arbitration to be conducted online. There are today transcription facilities which will give him the facility of a printout of whatever has been stated in the arbitration proceedings. So he can very effectively participate in the arbitration proceedings from wherever he was. So these facilities were not available in respect of the arbitration process that was offered by NBFCs. NBFCs also could not say that they were very much almost doing the same as what DRTs and SARFAESI tribunals are doing, because the appointment of members to DRTs and SARFAESIs were regulated by law, and it was ensured that independent members were appointed. So they could not take this parallel and say that you're discriminating against us because when nationalized banks have disputes, they go to DRTs. Yes, they go to DRTs, but then before DRTs, they have to pay a court fee. Before DRT, they would have, it is an independent member. There is a selection process for appointing arbitrators. So these are the differences between how a nationalized bank approaches an issue of recovering debt and how an NBFC approaches the aspect of recovering debt. NBFCs also pointed out and said, which was quite a valid argument, which said that now if you are going to say that only three arbitrators can be appointed by a particular company, then how will we find so many arbitrators? Now, if you have if an arbitration, a particular NBFC has, let's say, 20,000 arbitration, 20,000 divided by 3, where will I go for that many number of arbitrators? There are not that many number of arbitrators. So these were the problems that the NBFCs felt, and these were the problems which they presented before the Supreme Court when this business of unilateral appointment came before the Supreme Court. Why? How did the issue of unilateral appointment come before the Supreme Court? In Central Organization for Railway Electrification, originally in 2019, the Supreme Court held that Section 12 of 5 of the Arbitration Act does not bar former employees from being appointed as an arbitrator. It also examined the question as to whether the general manager's power to appoint arbitrators was valid and upheld the arbitration clause, noting that the respondent had the power to choose 2 nominees, ensuring balance. However, subsequently, in Union of India versus Dantia Constructions Limited, Justice Nariman doubted this proposition very much. And the matter was then referred to a 3 judgment. In JSW Steel Limited versus Southwestern Railway, the following issues arose for consideration. The JSW Steel Limited also raised questions about the judgment in the earlier round of the case in Central Organization for Railways. So the question that arose before the Supreme Court Constitution bench of the Supreme Court, whether an appointment process which allows a party who has an interest in the dispute to unilaterally appoint a sole arbitrator or curate a panel of arbitrators and mandate that the other party select their arbitrator from the panel is valid or not. This is the first question which the Supreme Court had to go into. The Supreme Court then gave to itself the second question, whether the principle of equal treatment of parties applies at the stage of appointment of arbitrators. The third question is whether an appointment process is a public-private contract which allows a government entity to unilaterally appoint a sole arbitrator or majority of arbitrators of the arbitral tribunal is violative of Article 14 of the Constitution. These are the questions which fell for consideration before the Supreme Court. Tracing the history of this difference or this controversy, the court first recalled the judgment, first of all in Shahidin GmbH, where the court examined whether a panel of arbitrators constituted by the Delhi Metro Rail Corporation, consisting only of government employees or retired employees, violated Section 12(5). The Supreme Court emphasized the importance of arbitrator independence, but did not prohibit the retired government employees from ultimately being arbitrators, and ultimately ruled that both parties should be able to nominate from a diverse panel of arbitrators. The above decision was then followed in DRF Limited. In Perkins Eastman, the court examined an arbitration clause where the CMD of HSCC was empowered to appoint a sole arbitrator. So it said, if you by yourself are disqualified from appointing an arbitrator, you cannot skirt this ban by appointing an arbitrator, you though not participating directly in the arbitration process. You cannot get around this ban by appointing an arbitrator, appointing a person who will act as an arbitrator. So while deciding the case, the Supreme Court recalled that there is certain fundamental foundational aspects of arbitration law. And these are the following. One is party autonomy. The Supreme Court held that the Arbitration Act prioritizes party autonomy in the arbitral process all over the world. This is a fact. There are certain fundamental foundational aspects of arbitration law all over the world, right? So party autonomy is the first, because it's a contract. It's a contract between two parties, and therefore party autonomy is supreme. The second it noted was that there are a set of mandatory provisions. I'm sure one of you here must be thinking, what is the point in Section 4 of the Arbitration Act which allows you to waive a right? The court pointed out that as far as Section 4 is concerned, it only allows you to waive what are non-derogable rights. Derogable rights are those that you can get into an agreement and say that we do not, this does not apply to us, or act in such a way that the derogable rights are waived. But there are non-derogable rights which you cannot waive. I mean, there are some countries which have passed arbitration acts which have made all this very simple. In the schedule to the act itself, they say what derogable or non-derogable provisions of the act are in respect of Section 4. Unfortunately, this is something which I have also now recommended to the committee which is looking into it. Please bring a schedule to the act which says what are the non-derogable and derogable rights, instead of having courts break their heads over it. In fact, in 2015, when we as part of Law Commission sat to finalize the Law Commission report, Justice A.P. Shah, with great vision, said that let us also have a schedule which says which provisions are prospective and which provisions are retrospective. It is on things like this courts waste enormous amount of time. So actually we drafted and placed it before the government that because there are going to be amendments that are coming out, it is going to be inevitable that courts are going to be discussing what are prospective, which provisions of the amendments are prospective and which provisions are going to be retrospective. Because of all this theory that procedural law can always be retrospective and substantial law can always be prospective, increasingly in legal regimes, the line between procedural law and substantive law is getting blurred. And the court also have their take on what is procedural, what is substantive, and what is procedural. Therefore, to eliminate this confusion, Justice Shah suggested that kindly ensure that there is a schedule to the act which says which of these amendments will be prospective and which of the amendments will be retrospective. That is another request that has been made to the Parliamentary Standing Committee now and to the government, that when you are going to bring out these amendments, these contemplated amendments, please have a schedule which sets out which of these provisions will be prospective and which of the provisions will be retrospective. So, since we do not have a list of derogable provisions and non-derogable provisions, it is left to the court at every stage to say whether a particular provision, which one of the parties claims that derogable provision, it is only a derogable provision, and therefore the other party has waived his rights with regard to compliance to that. Instead of just making an argument, it would have been better if it had been part of the act itself. Since it is not, it is now within the domain of the courts to rule which are derogable and which are not. The third aspect which the Supreme Court pointed out is appointment of arbitrators. Interestingly, on this, once again, I should say Supreme Court has gone back and forth on this. And under section 11(6), see, there are two things to a challenge or an application, I should call it challenge, an application under 11(6). One is, there are issues relating to the arbitrability of a claim. Quite right, Supreme Court has said arbitrability of claims can only go before the arbitrator. But existence of a claim, in Magic Guide, the Supreme Court said, existence of arbitration is something which has to be decided by the referring court. You cannot derogate from that. The only problem about that 11(6) is that 11(6), if you read the Arbitration Conciliation Act book, there is one asterisk placed above 11(6). And it is supposed to be repealed, but it has not been repealed. In the 2019 draft amendment, which has not been notified, it is suggested that provision should be repealed, but it has still not been repealed. So that is causing a lot of confusion. Actually, under section 11(6), 11(6)(a) still exists, and under that, the court still has to go into existence of the arbitration agreement. That 11(6)(a) provision, since the notification has not come through, unfortunately, if you take all the books on arbitration, there is a lot of confusion that is caused because this provision, there is a asterisk mark and it says repealed by a particular provision, but that has not yet happened. So, 6(a), the Supreme Court, or as the case may be, the High Court, while considering any application under subsection 4 or subsection 5 or subsection 6, shall, notwithstanding any judgment, decree, or order, confine to the existence of an arbitration agreement. But if you take an arbitration conciliation book, you will find a footnote which says omitted by the Arbitration Conciliation Act 2019. But this omission has not been notified yet. And some courts are not taking note of this. So unfortunately, there are courts which are still saying that even existence of the arbitration agreement is going to be sent back to the arbitrators for the decision, which is principally wrong. The fourth important point is equality in proceedings. That means equal treatment of parties, which you will find asserted in section 18. Then the court said, this is not a fundamental aspect of arbitration law, but the court also said, public-private arbitration does not provide a special regime for disputes involving public authorities. I want to differ with this. This is a wrong finding of the Supreme Court. I'll tell you why. You take statutory arbitrations. Statutory arbitrations are recognized under section 2(4) of the Arbitration Conciliation Act. Right? 2(4), I'll read 2(4). This part, except subsection 1 of section 40, 41, and 43. That is, we are talking about part 1, chapter 1. Part 1, chapter 1. Shall apply to every arbitration under any other enactment for the time being in force, as if the arbitration were pursuant to an arbitration agreement, and as if that other agreement were an arbitration agreement, except in so far as the provisions of this part are inconsistent with that other enactment or with any rules made thereunder. So what happens is there are any number of what are called statutory arbitrations. These are arbitrations under Cantonment Act. There are statutory arbitration under the Indian Electricity Act, statutory arbitrations under the Land Acquisition Act, statutory arbitrations under the Railways Act, Forward Contract Regulation Act, Telegraph Act, Electricity Supply Act, MSMED Act. In the light of this, and in the light of Section 2(4), what the Supreme Court is saying is contrary to 2(4). Unless we understand that what the Supreme Court means is only public-private arbitration regulated by a contract and not a statute. If it is read in that context, what the Supreme Court says is right. But we must bear in mind that there are a whole lot of statutory arbitrations to which this principle of unilateral appointment of arbitrators does not apply at all. For example, take the Land Acquisition Act. Under the Land Acquisition Act, the initial award is passed by somebody in the revenue authority, in the rank of a revenue authority. From that, you can find a reference to the collector. And from the collector's order, it is of application under Section 34. Now, question that I'm asking is this. These are lands of farmers who are being acquired. These are lands of agriculturists which are being acquired. You must have some sort of a fair system to resolve these disputes. But what are you doing? You, at the first level, the land acquisition officer, is an officer of the government. He is not going to act on behalf of the agriculturists. At the level of the collector, it is the collector who is in charge of disbursing the funds once the award reaches a finality. So he has a vested interest, the very same principle which the Supreme Court holds to say you cannot have unilateral appointment of arbitrators in the private sector becomes acceptable in the public sector. Because then the collector passes an order. And just imagine the problem of a judge who is hearing a Section 34 application. His grounds to interfere with the order are very limited. So how will he give any relief to a poor agriculturist if this is to be the framework on which it operates? Therefore, the reference to public-private organization, please do not read this observation of the Supreme Court to mean that in every arbitration where the interest of the public and private are involved, then all these principles relating to unilateral appointment of arbitrators will apply. No. By virtue of Section 2(4) and by virtue of various provisions in the respective acts, it is those provisions that will apply and not the provisions relating to the unilateral appointment of arbitrator process that has been found by the Supreme Court. How these two are different, I don't know. Possibly sometime, someday, somebody is going to file a writ challenging the constitutional discriminatory aspect of this. But as the law stands today, there are nearly 25 central legislations which have these statutory arbitrations. Likewise, every state government has its own, for example, under the Cooperative Societies Act, under the Societies Act, and the Chit Funds Act. So many of these, there are registrars who are appointed to act as arbitrators, and they could well be questioned as not being impartial or independent. So these are aspects that need to be questioned at a much more involved level. So ultimately, after discussing all this, the Supreme Court held that the nature of functions of an arbitral tribunal, the court pointed out that an arbitral tribunal functions as a quasi-judicial authority. It is bound by procedural and substantive law to make decisions or award. Then it said that there is a fundamental principle of equality in the appointment process, and therefore both parties must participate on the process of appointment of an arbitrator. Then it said that there are principles of natural justice will have to apply, and therefore there is no warrant for any of the parties to detract from that. It also said that it is necessary to bear in mind the doctrine of bias, and the court pointed out that bias arises when a judicial or quasi-judicial body has a predisposition towards one party. And then it said there is a test of real likelihood of bias. There are some automatic disqualifications, and there are certain disqualifications which only require a declaration by one of the parties to the proceedings. So, in all, the court summed up. I should tell you that the judgment of the court was not unanimous. 3 judges held in a particular way, and 2 other judges rang in their notes of dissent. But since in our law we only have to go by what the majority decides, the principles that the majority laid down are that there is equal treatment principle. PSUs and arbitrators panel, it said that the PSUs cannot curate their own panel and place in that panel retired government servants and say that you must pick your arbitrators only from here. It outright rejected the concept of unilateral appointment of arbitrator. It interestingly brought in the provisions of Article 40 of the Constitution to determine rights which are private in character, and waiver on the basis waiver of bias allegation. Court once again pointed out that non-derogable provisions cannot be waived. And interestingly, in the last paragraph, the court says that this judgment will have prospective application. Now, what does this mean? Suppose an NBFC has till date appointed only its own arbitrators, and it has passed an award, right? Now, even before this judgment, there have been judgments which held that unilateral appointment of Eastman Perkins has said that unilateral appointment of arbitrators is not valid. So what does the court say by saying that these provisions will operate prospectively? Can it then be said that because the court says that this judgment is to operate prospectively, all awards that have been passed till now are valid in law? All this must be applied only in future, and it has no past application. Is this the interpretation? I'm sure somebody is going to go before the Supreme Court and seek clarification on this aspect. So let us now, on the basis of this, see what NBFCs, PSUs must do. Let us look at the various classes of arbitration. Existing arbitration proceedings. What do you do in existing arbitration proceedings where unilaterally arbitrators have been appointed? The first thing is to cancel such appointments, not take the risk unless the Supreme Court is going to clarify its earlier judgment and says prospectively means only from the date you can't do all these things. If you had done it earlier, it's all right. For that, you need to move the Supreme Court and get that clarification. Otherwise, it means cancel all unilateral appointments. What do you do in respect of thousands of contracts which you have already filed? Try and move the central government because I don't think anybody is going to agree to go back to a position where the NBFCs themselves can appoint arbitrators. So what can you do? You can approach the central government and ask for saving clause, which protects what you have done in the past and says that from the date of this amendment, unilateral appointment of arbitrators is bad, but it will not affect any awards passed earlier. So this is the second, either go before the Supreme Court and get a clarification, or go before the Law Ministry and tell them that your amendments are on the anvil, and when you pass these amendments, kindly ensure that this is the route that you take. Awards already passed by arbitrators must suffer the same fate as what I said earlier. existing arbitrations and awards already passed, try to get some saving at the hands of the Supreme Court. If that does not fail, move the law ministry for exempting the application of law to events that have already happened. A, arbitrations in process. B, awards already being passed. But as a matter of form, it is better that you start going towards institutional arbitration. For example, an institutional arbitration, even if an institution appoints the same arbitrator in multiple arbitrations, there is no bar under the Act today. The bar is only with regard to the same party appointing an arbitrator again and again. So you can make use of this provision of law and ask for the appointment of arbitrators, and through a appointment of arbitrators through institutional arbitrations, you will be completely clear of the. Today, most of these arbitrations, institutional arbitrations, offer online facilities, which will also bring down the cost of conducting arbitration for NBFCs. They can also ensure that all these arbitrations are time-bound, right? NBFCs are never going to go back to a regime where they can say, my managing director will be the arbitrator. Government is not going to agree. Court is not going to agree. Your only current problem is, what do I do with existing contract? One other recourse that is open to you, possibly for you to think, is print an addendum to the existing agreement with all holders who are your customers, and circulate it to them, get it signed, where they agree to unilateral appointment of arbitrators. If you are able to swing them all, convince them all that this is necessary on account of changes in law and on account of the judgment of the Supreme Court, I am sure at least a sizable number of them will oblige, and therefore, going forward, your route is clear, you don't have to worry. So these are some of the things that emerge from this judgment. And since this judgment went into several aspects of the arbitration law, and since I have touched on these various aspects, I think there were a lot of questions that were put to me, and I take the rest of my time to answer these. Because if you can read those questions from the chat box, then I can answer them.
Yes, sure.
I don't know whether it is possible to screen share the question, but if you can screen share the question.
It's on the chat box itself. Kindly elaborate an arbitrator's fees. Is it mandatory that fees must be shared equally?
It is equal treatment of parties means that the fees must be shared equally. There is no exemption as far as that is concerned. It must be shared equally.
Next question is, can an arbitrator have the power to summon a witness?
Has the arbitrator power to?
Summon a witness.
Yes, he has power to summon a witness, and he has powers under section 27 of the Act also to issue section, I'll just read the provision. Persons failing to attend in accordance with the court, the 27 court assistance in taking evidence, the arbitral tribunal or a party with the approval of the arbitral tribunal may apply to the court for assistance in taking evidence. So there is a process set out under section 27, and he has to follow that process to summon the witness. But if he follows that process, then he can summon the witness, because 27(5) says persons failing to attend in accordance with such process or making any other default or refusing to give their evidence or guilty of any contempt of the arbitral tribunal during the conduct of arbitral proceedings shall be subject to the like disadvantages, penalties, and punishments by order of court on the presentation by the arbitral tribunal, as they would incur for the like offences in suits tried before the court. So the status of a person who is being summoned following an order of the court after provisions of section 27 have been followed will suffer the same disadvantages as a person who refuses to appear before the court. So that facility is available, but you must educate yourself about the exact way by which you go through it. And that is contained in the provisions of Section 27 of the Arbitration.
So we have Sanjay Pinto also to ask a question. I have asked Sanjay to unmute himself. Mr. Sanjay?
Sir, good evening.
Good evening.
Can you on the camera? That would be better.
Yes, one sec. So my question is in the context of the interplay between sections 28.2 and 28.3, sir. I mean, the role of an arbitrator as an amiable compositor and dispensing justice on the principle of equity versus 28.3, which talks about trade usages. There's a conflict between these two provisions, and sometimes arbitrators find it difficult to navigate, sir.
I don't think there should be any difficulty on this, because this I'm able to see in many parts of the country, when there is a dispute with regard to family businesses, what happens is both parties, I'll tell you the reason why this provision was brought in. When there are disputes between various parties, mercantile communities, mercantile families, what they do is they agree to the arbitration by a respected member of the community. Now, that respected member of the community knows this business very well. He knows the parties involved very well. But when he writes a judgment, he will not be able to write a very detailed judgment which may possibly stand scrutiny in a court of law. So where these mercantile communities, this must be done with the consent of both the parties. An arbitrator unilaterally can't say that I am going to function as an amiable compositor. He has no right to do that. If both parties confer on him that power, or where circumstances can be shown to show that such a power was vested in the arbitrator, then he can even give a one-line order, in spite of the fact that the Arbitration Act says that orders without reason are basically susceptible to be challenged in court. When you appoint somebody under Section 28.2, shall decide ex equo et bono or amiable compositor only if the parties have expressly authorized it to do so. So this is brought in to preserve that type of business that has been done for centuries in this country. 28.3 is mandatory and it is binding on the parties. So 2 and 3 can never pose a problem, because 2, you need a sanction from the parties that we authorize you to act like this.
Thank you, sir. Because if I may ask the second question, provided there's time, because so I can ask it at the end if others have.
No, you can ask.
Thank you, sir.
In this way, sir, because of you, Mr. Sanjay has come across. We have been requesting him to take a session.
Oh, good, very good.
Very, very soon. Thank you, Vikas. Thank you, sir. So my second question is, can an arbitrator strike down a particular provision of an agreement if it is opposed to public policy under Section 23 of the Contract Act, considering that an arbitrator himself is a creature of that same agreement?
No, I don't see how he can strike down a provision, but if he is to act in consonance with the laws of the country, then he can deal with that provision as being applicable or not applicable.
So in the context of that particular interpretation being that the root of if the root of their entire dispute hinges on that particular provision, in that context I'm asking, sir.
That's what I'm saying. If it is, let's assume there is a particular clause which is challenged in the arbitration proceedings as being an unconscionable provision. Or let us assume that there is a challenge taken that this provision is undue influence, coercion and all that. He has the power to deal with it. But primarily the provisions of the law of the contract between the parties will come. Prima facie, that is what the arbitrator has to go by. But all the defenses that are permitted for him under the provisions of the Contract Act are available to a party challenging the contract before the arbitrator. Because you are well versed with the provisions of the Consumer Protection Act, you know that there is something called unfair terms of contract, but that is applicable only to a consumer business contract. It is not applicable to a business contract. Whereas in countries like England, even the unfair terms of contract is applicable to certain types of businesses. In India, unfair terms of contract is applicable only in the consumer court. So he cannot take an argument that it is unfair and therefore not binding on me. That argument he can't take. But save that by any means whatsoever open to him under law and by application of the existing law, he can take arguments like it's an unconscionable contract, that it is an illegal contract, and it is a contract devoid of consideration, in which case the arbitrator has the right to rule accordingly after appreciating facts of the case.
Thank you very much.
Sanjay is primarily focusing on that central Indian versus Brojanath to state therein that section 23 should come into being.
Yeah.
That's his primary. I think Sanjay wants to take a cue from section 23 of the Indian Contract Act, relying upon central.
All that will be available. It doesn't mean that the Indian Contract Act ceases to exist once the person goes to an arbitration. Of course, after the recent amendments to the Indian Specific Relief Act, parties, the discretion vested with the court vanishes. See, basically, the Britishers came to India only as traders. They had no imperial ambitions. If you look at history, it has always been the case that trade will follow the flag. That is, the country will be conquered, and after the country is conquered, trade will follow. But in India, it's a very strange phenomenon in history where this was reversed. The flag followed the trade. The Britishers first came in only as traders, had predominant interest only as traders. Until they left, they protected their interest only as traders, predominantly. The territory was necessary for them to bolster whatever trade interest they had. So, the Specific Relief Act, for example, still gave the judge, who were all British, people brought from England, the right to determine for a long time. The Britishers were only British judges, the judges were only British judges. Till the scene changed after, say, 1880 or 1890. When the Madras High Court was formed in 1862, all the 5 judges were Britishers. So that changed over a period of time with the induction of Justice Muthuswamy here, and slowly more and more Indians came to be inducted. But the point is, they wanted to vest the power in the judges that even if they, entered into a contract which apparently on the face of it was binding on them, they could squirm away from that through projecting to the judge that it was onerous on them, it was hard on them. That power, therefore, was given to the judge. I don't know why we took till 2018 to amend this. It should have been amended in 1947 itself after the British left. But till 2018, we still gave courts a power. We called it a discretionary remedy and gave courts a power of decreeing specific performance or not decreeing specific performance. But ultimately, Parliament woke up to this and said, why are we? Because in the ranking, international ranking of enforcement of contracts, we ranked very, very low. And one of the reasons which Parliament decided was the reason for this was that discretion was given to the courts to enforce contracts, and therefore that discretion was taken away only by parliamentary amendment in 2008.
Thank you, sir. Thank you very much. I learned a lot from your lectures. Thank you, Vikas.
Thank you.
Thank you, Sanjay. I will connect you after the session.
Sure.
Yeah. So this is there any provision to challenge an award by an indigent person, and whether such a provision would be valid?
A provision to challenge?
By an indigent person.
What is I don't understand this. An award is
given
to an arbitrator.
Yes. Can you challenge an award can the award be challenged by an indigent person, and whether such provisions would be valid?
Yes,
probably speaking.
Challenge an award, and there are provisions in the CPC where if you are not unable to pay the court fee, you can apply to the court and ask for a remission. It applies to everything.
One of the questions is, can unilateral appointment of an award be challenged under section 47 of CPC as non-quorum judice?
Yeah, day in and day out, unilateral appointment of arbitrators are being challenged in courts and are being set aside by courts.
the last question is, in terms of SBP versus Patel Engineering, Section 16, jurisdictional issue, should it be decided in Section 16 stage itself or thereafter?
It is possible for you to take out an application before the arbitrator and ask him to decide it as a jurisdictional issue. And arbitrator can decide it as a jurisdictional issue. But then you will have to wait till the award is passed for you to challenge it under Section 37. Section 37 deals with, I think, 5 classes of orders. Other than that, it can't be taken in appeal. So you can possibly raise this issue. Arbitrator can rule on it. See, 1A, B, C, 2A and B are the only classes of cases in which a Section 37 applies. Refusing to refer the parties to arbitration under Section 8. Granting or refusing to grant any measure under Section 9. Setting aside or refusing to set aside an arbitral award under Section 34. An appeal shall also lie to a court from the order of the arbitral tribunal accepting the plea referred to in subsection 2 or subsection 3 of Section 16. That is, if the arbitrator says, I have no jurisdiction in the matter and accepts, then the arbitration comes to an end and you can file a Section 37 appeal. Granting or refusing to grant an interim measure under Section 17. Only these 5 classes of cases are appealable. So in Section 16, if you file and if you are successful, the other side can challenge it under Section 37. Otherwise, if the arbitrator dismisses your application, then you will have to wait till the arbitration award is passed and challenge it under Section 30.
Thank you. This was the last question. And thank you, sir, for enlightening us. Thank you. And those who want a deeper dive, they can always join these classes, which the Nanki Palki Wala classes, arbitration center is going on under the aegis of Mr. L Rajah. Thank you, everyone. Stay safe, stay blessed.